Good afternoon. Just a brief reminder before we start here, if we should have any technology-related problems, everybody just take a deep breath and we'll pause while our experts work us through it, and we'll get back on. This will, hopefully, our March dockets, hopefully will be the last time. Although Zoom has worked very, very well, we're all looking forward to going back to starting in April in the courtroom oral arguments. This will be the third time we have set it up to go back in the courtroom with oral arguments, and every time we do, we seem responsible for a new surge. But in any event, if we do have any problems, just we'll pause and work through it. If we could please call the case.
John Doe 1 et al. Versus Woodland Presbyterian et al.
We'll hear from the appellants, and as I understand it, you've already explained to the Madam Clerk what we're doing as far as the time. Each side has a total of 25 minutes, and you all have told her how to divide it up, correct?
Correct.
And the order in which you're going, I hope, as well. All right, thank you. We'll hear from whoever's first.
Gary Smith for the plaintiff's appellant. I have 8 issues relevant to our inquiry today. Some of them bleed over into each other. And
I'm sorry. I hate to interrupt you here, but look, I just want to make sure on the timing we've got right here. You had up, Ms. Dempsey, you had up 21 minutes for Mr. Smith. Is that?
Yes.
Okay. So you're taking 21 minutes.
Rebuttal time.
Yeah. You're taking 21 minutes of the 25.
Correct. But I am having technical difficulties here. I don't know if you are on your end or not.
No, we hear you fine.
Okay.
Okay. Make sure, I want to get this clear. I don't want to shortchange anybody. Let's go ahead and tell me what order you're all doing and how much time you're taking.
Plaintiff is taking 21 minutes on the argument in chief and 4 minutes for rebuttal.
Okay. All right. It's the appellants. It's the appellees. We've got it. I managed to confuse myself, which happens. So I'm sorry to interrupt you. Please continue.
As I indicated, I have 8 issues. They bleed over into each other somewhat. I'm going to try to approach them in a logical order, but I want to begin with the issue of the count that alleges negligent infliction of emotional distress claim with some other aspects to that claim for the 2019 event, keeping in mind that the lawsuit was filed May 19 of 20. In June of 19, the plaintiffs contacted the then pastor at Woodland, as well as former Pastor Sanford and the former assistant pastor, and found new information. But as a result of that, the church released the plaintiffs' names without their permission to the media. And we have asserted that that is a cause of action, negligent infliction of emotional distress. The trial judge granted a motion to dismiss on that count, not on the statute of limitations, of course, because the one-year statute had not run. The defendants merely asserted, well, there's no cause of action for that. We did it, but there's no cause of action. We disagree. Interestingly, the trial judge stated her reason for dismissing that count was because we did not allege defamation. We did not allege libel or slander. And of course, it's true. We did not, because that would have required us to contend that the communication to the media, inappropriate as it was false. It was not. It was true. It was not a defamation claim. So naturally, we didn't allege defamation. We alleged negligent infliction of emotional distress. So we came back on a Rule 60.02 motion before the trial court to say, look, you said we didn't allege defamation. It's correct. We didn't. We didn't intend to. This is not defamation. The trial court denied that 6002 motion, but without explanation. Just said, I still grant the motion to dismiss. We contend, obviously, that that is an error for a number of reasons. Clearly, it was not a defamation claim. We couldn't claim defamation. But the church did not have authority to release the names of these individuals to the media. It has been the court's policy. We've expressed this in our brief and cited the authorities, including from the Tennessee Supreme Court, that it is the policy of the courts of this state to protect the identities of sexual assault, particularly juveniles. And of course, these men were juveniles at the time that the sexual assaults occurred. So what they did was wrong. It does constitute a cause of action. It is clearly not barred by the statute of limitation. The defamation ruling was wrong. Additionally, we asked for discovery on the issue, which we were denied, and I'll say more about that later with respect to some of these other causes of action. But I just think it's inarguable that the court was wrong. Her original reasoning was wrong. We have expressed a cause of action, and there has been nothing to suggest that that should have been the subject of a motion to dismiss. Now, secondly, the court also, pursuant to a motion to dismiss filed by all defendants, ruled that the statute of limitations had run as to the original sexual assaults. We disagree. We rely on the Red Wing case versus the Catholic Diocese of Memphis. And I'm going to make two references to Red Wing that I think are applicable here. The first one's this: Red Wing held that while it may be true that a person who has been injured, including by sexual assault, may be aware of the injury, but may not know who or have reason to know of what one or more persons, or in this case, entities, were at fault and the cause of the injury. In this case, the individual claimants knew that Pastor Stanford sexually assaulted them. What they did not know was the role that the institutional defendants played in that, which I'm going to talk more about in a moment. Nor did they have any reason to know the role that the institutional defendants played. What they did do back at the time was eventually, and keep in mind, these were young men that the record will reflect were members of that church. Pastor Stanford was helping the families out financially who were in financial need. He would bring these boys over for overnights on the weekends, make alcohol available to them, and after they'd go to sleep, he would sexually assault them. It's just, it happened. There's not going to be an issue about whether or not that happened. It happened. Eventually, they did, as juveniles, go to a Sunday school teacher and report what was happening to them. She made them confront Pastor Stanford. He denied that it was going on, and basically they were told, go away. They were shut up. They were shut down. They were not believed. And so they dropped it then. But later, as adults, back in 2019, they did make inquiries and found out that there was information that had been withheld from them. And among the things that they found out was that the Sessions, an organization within the church, had learned back in the 90s that Pastor Stanford was having young boys overnight at the house which the church owned, but in which he lived, and that there was suspicious activity. And so they confronted him, and he angrily told them, I'm not doing anything wrong. You may own this house, but it's my house. I live in it, and I'm going to do what I want to. And they dropped it. What they did do in terms of, quote, an investigation was to ask him about one incident on one specific day about one specific person, not these plaintiffs. He denied it happened, and they quit. No further inquiry. And they let him continue to do these overnights, which allowed him to continue to do the abuse.
Counsel, let me ask you a question, make sure I understand here. Am I right that it's not you're not saying that, look, the plaintiffs, once they became adults, could not reasonably have learned the succession of organizations. And that was something I assume that was reasonably available to them. Is that correct?
Well, the record is unclear on that because we've been denied the discovery. I think what can be said is that
Is there anything in the record one way or another that says whether or not that hierarchical organization was reasonably found without having discovery through a court?
There is nothing that says it was or was not. I think, look, if you ask me, was it there? Could they have found some mechanism to figure out what the hierarchy was? Probably so. There was nothing in the record that I think that proves that one way or the other. But the key is, even if they knew about the hierarchy, it would not have revealed to them the internal workings of the governance and the investigation, that pseudo investigation that was done and dropped, nor would they have learned that back in the early 90s, before their abuse, the Big Tent Presbyterian Church, of which Woodland was a member, had conducted a study into sexual abuse in the churches, found that they did not have sufficient policies and procedures to protect against it, or to investigate it, or to provide support to the victims. And then when the proposal for adopting those programs was presented to the big church, they rejected it. And so therefore they went without policies and procedures that in turn would have helped prevent this from occurring. So the answer to your question is, whether or not the hierarchy was available to them, there was no way at that point for these men to know of the governance issues and what was known up through that hierarchy that was not made available to them. So compare this to Red Wing. In the Red Wing case, they make ultimately 4 findings on a similar motion to dismiss for sexual abuse that occurred to a child who many, many years later came forward after learning of more information about what the diocese knew. Those 4 are this. Number 1, in Red Wing, the diocese concealed its involvement and the plaintiff had no reason to suspect he was misled. Exactly what happened here. Number 2, his inquiry of the diocese was sufficient to constitute reasonable diligence. Exactly what we have here. They went to the Sunday school teachers. She confronted with them Stanford. He denied it, and they were not believed, so they shut down. 3, because of 1 and 2, Red Wing held that presents a question of fact. And that question of fact, number 4, is subject to being determined after discovery. And we have asked for discovery in this case. At every turn, the judge did not allow us to have discovery, including on the governance issues. We issued leading discovery with the complaint to these institutional defendants, which would have been revealing on what they knew, what their participation was, what their knowledge was with respect to sexual assault, investigation, et cetera, and adopting policies and procedures. We were denied that. We know it exists, but we've been denied it for discovery and for putting it into the record. So in addition to the claims as to Woodland for negligent hiring, negligent retention, negligent supervision, negligent training, negligent infliction of emotional distress, and a lack of policies regarding sexual assault, we segue into the tolling issue. The statute, we believe, under the authority of Red Wing and fraudulent concealment. And in our brief, we discussed, as Red Wing did, fraudulent concealment and equitable estoppel. I will concede that I think fraudulent concealment is the issue here under these factual circumstances, just as the Red Wing court said was the appropriate remedy as to tolling in Red Wing.
I'm sorry, what did you say as to fraudulent concealment?
It is the way to analyze this issue, not the equitable estoppel. And that was the finding also in Red Wing, that equitable estoppel did not apply. Fraudulent concealment was the proper test.
All right, what do you say the complaint, this went off a motion to dismiss, right?
Yes.
What in the complaint shows fraudulent concealment or alleges fraudulent concealment?
The factual circumstances are in the complaint that, as I outlined earlier, in the 90s, the Sessions pseudo investigation, and ultimately, by the way, not to skip forward, but to skip forward anyway, in 19, when they came back and they talked to the assistant pastor from back in the 90s, the assistant pastor to Pastor Stanford, he said, oh, this was thoroughly investigated back in the 90s. Well, as it turns out, we now know for sure that's fraudulent concealment. They're still concealing it. No, it was not. They asked about one kid on one specific exact day, which Stanford denied, and their complaint was never investigated. They never revealed to these young men that they had suspected Stanford of inappropriate conduct, and the Sessions confronted him, and he simply told them to go fly a kite, and they accepted that, which allowed their abuse to continue. Now, it was interesting that, keeping in mind that the allegations against Pastor Stanford and the institutional defendants are completely separate claims, we also sued Pastor Stanford. He did not answer. He gave us, the plaintiffs, handwritten responses to our leading discovery. Come to that, back to that in a minute. But he never answered the complaint. So we moved for default judgment. And at the hearing for the default judgment, we were on Zoom. Pastor Stanford was on the Zoom motion. We made the appropriate presentation as to the application of default judgment being appropriate. The court then inquired of Pastor Stanford, do you wish to address this? And his answer was, no, Judge, I am ready for the judgment. At that point, the trial judge instructed us to draw the order granting the default judgment. Then the institutional defendant spoke up and said, no, we don't want a default judgment entered against him. The judge says, well, you haven't done anything. I'll give you a week to get your house in order on your objection. So we came back the next Friday, and they objected to a default judgment. The court said, well, I guess it will prejudice you. So I'm not going to grant the default judgment anymore. I'm going to hold it in abeyance while this case goes up on appeal. Well, the prejudice in that situation fell on the plaintiffs because we wanted to preserve. We also moved, in addition to the default judgment, we also moved to take the deposition of Pastor Stanford in order to preserve his testimony. We were denied discovery on that. The judge would not let us even take his deposition. A man who was 76 years old with cancer and all other kinds of medical anomalies. We asked to be able to file because she had already granted the defendant's motion back on the front end that there would be no discovery until the motion to dismiss was heard. Motions to dismiss were heard. Now that order was supposed to expire when the motions to dismiss were heard, and in this case, granted. We asked to be able to file the discovery responses of Pastor Stanford that he had served on us, but had not filed with the court. In part, that would have shown his medical condition and would have served as a predicate to allow us under Rule 2702 to take his deposition to preserve his testimony. She denied us the deposition. She denied allowing us to file his discovery responses, which pertain to the medical condition and some of the substantive issues in this case. We asked her because, again, Pastor Stanford was on the Zoom call motion. Let him tell you his medical condition, because she had said, you know, if he has a serious medical condition, that'll be one thing. We asked her to allow him to address that, which he was willing to do. And she said, no, we're not going to do that in Division 5. So she did not allow him to speak to the medical condition. She did not allow us to file the discovery responses of him, which related to the medical condition and other things. So all of those, we believe, were an abuse and error by the court, and significantly a prejudicing factor to the plaintiff.
Counsel, the trial court, as I recall, said that the reason it wasn't going to address letting you file his discovery responses was the trial court said it had lost jurisdiction because of the appeal. Was that the basis for denying you discovery?
That is exactly
filing that discovery response.
Yes, that is exactly the basis that the court used, but of course that's wrong under 2702. 2702 specifically authorizes the ability to take the deposition and to file his written discovery while pending appeal. So, but you are correct. That was the reason that she utilized. The defendants, two of the defendants, Presbyterian Church USA and Evangelical Presbyterian Church, challenged jurisdiction on personal jurisdiction grounds, and the trial judge agreed with them. We believe again that she was wrong. There would be a number of issues related to whether or not there is personal jurisdiction, because we are talking about their duty to supervise, the governance, the failure to investigate, the failure to have policies and procedures, knowing specifically of the risk of sexual assault in the church setting and the imbalance of power that permits that, and the study that they did in the early 90s that I mentioned earlier that acknowledged lack of policies, acknowledged needing the policies, proposing policies, and then it was all rejected. We know that Pastor Stanford will say that the responsibility for investigating sexual assault is in the local church, but under the oversight of the hierarchy of the presbytery. So the personal jurisdiction also issue was stymied in its completion by the lack of discovery. We issued discovery to them, which reflected on this issue. It is appropriate to have that discovery before a motion to dismiss is heard. And in essence, the trial court granted their motion to dismiss on personal jurisdiction with a blank slate. And had we been permitted to have that discovery answered and or any follow-up to that as may have been warranted, had it been answered, the ruling could be made without a blank slate. So with that, unless the court has any other questions, I will defer to the defense.
I hear none. You have your time for rebuttal. Thank you. We'll hear from the appellees now.
May it please the court, Chris Ersman on behalf of Woodland Presbyterian Church. The trial court's ruling should be affirmed in all respects. The trial court did not err when it dismissed all claims arising from Woodland's conduct in the mid-1990s because plaintiffs discovered their causes of action against Woodland in the mid-1990s. Given plaintiffs' current ages and the application of 1 year statute of limitations plus 1 year tolling after the plaintiffs reached the age of majority, all of their claims expired no later than 2003. The trial court also did not err when it determined that plaintiffs failed to state a claim for negligent infliction of emotional distress, or NIED, against Woodland. Note here that plaintiff's NIED count is levied against all of the defendants and encompasses conduct that occurred in the 1990s and in 2019. The NIED claims stemming from the 1990s are barred by the statute of limitations. As to the alleged torturous conduct in 2019, the complaint alleges at paragraph 47, upon information and belief, Woodland and or members of the session and or one of the other defendants revealed their identities as sexual abuse victims to the news media, causing further anxiety, pain, and suffering. That's the nature of the 2019 claim. Critically, in the complaint, plaintiffs do not allege the existence of a special relationship with Woodland in 2019, such that Woodland owed a duty to keep plaintiffs' identities confidential.
Let me ask you about that, counsel. Is there any question that these plaintiffs, when they were minors, I don't know if they were members of Woodland, but they and their family were attending Woodland, correct?
That's what's alleged in the complaint, yes.
That's what's alleged in the complaint. And you're saying that in relation to what the complaint alleges happened back then, did the church have a duty back then not to disclose this information?
So there is no allegation regarding a disclosure in the 1990s.
I understand that. But my question was, do you agree or disagree that the church had a duty to their church? I don't know if they were, again, I don't know if they were members or certainly their attendees not to disclose this type of information.
Respectfully, I don't agree. I don't know the letter of law on the mandatory disclosure statute as in effect in the 1990s.
Well, the mandatory disclosure statute didn't require disclosure to the media, did it? Ever?
No,
Okay.
Judge.
All right.
Absolutely.
What I'm trying to get at here is it your position that this church, because I had no duty? I think that was the basis for the trial court's finding, wasn't it? That there was no, trial court actually went off defamation. Is it your position that the church had no duty to these members or former members not to disclose this information to the media?
Your Honor, yes, with this clarification, as members of the church in the 1990s or as attendees of the church, there can be special relationship with them, the clergy penitent relationship, for instance, in which communications would be offered in confidence and cannot be disclosed or should not be disclosed to others. The point here in 2019 is that the plaintiffs had no relationship with the church in 2019 to create a relationship of one of confidential communication or privity with the church in 2019.
So the duty, if there was a duty when they were there as members, ended?
Yes. Because
Okay.
that relationship I'm sorry.
So it's your position that once they left as members of the church, then the church had no duty not to disclose to the media any information about them that had been obtained while they were members?
No, Your Honor. I believe that information would need to be withheld in confidence, but this information that the plaintiffs are alleging was disclosed in 2019 was provided to a different pastor, to different leadership at the church in 2019. It's not a continuation of the same church members from the 1990s to 2019 when this new disclosure was made,
but it involved,
to a different pastor.
But the allegations involved things that were alleged to have happened when they were members. That's
Allegedly.
correct, right?
Allegedly, yes.
Allegedly, yes. That's why I said it was alleged. Okay. All right. Go ahead. I'm sorry.
And if I can, just circling back to that, the basis for the trial court's dismissal of the NID claim was one of no pled duty, no special relationship. It was also that so the tort for NIED necessarily includes extreme and outrageous conduct. And there is no precedent here in Tennessee, certainly that I'm aware of, where this type of communication has been found to be extreme or outrageous. The context in which NIED has been sustained really deals with grotesque injury, death, dismemberment. And I cited to a few cases where some very unfortunate events occurred and bystanders suffered NIED or emotional distress. Circling back, Your Honor, briefly to, because my time is limited here, to the statute of limitations issue, I want to talk about the accrual of the cause of action here. The complaint quite clearly establishes that plaintiff's claims against Woodland accrued in the mid-1990s. And it's just important here that the court bears in mind that the complaint is what is being analyzed, not counsel's characterization of what the complaint says or doesn't say. So plaintiffs allege that Mr. Stanford was the former lead pastor at Woodland, and he has sexually abused the plaintiffs inside their home in the mid-1990s. Plaintiffs knew that Stanford used church funds from the Church Benevolence Fund, over which it had control to pay for the family's utility bills on occasion and pay for groceries. They know that they slept over at Pastor Stanford's house, which was owned by Woodland. Plaintiffs knew or allege in paragraph 17 that Woodland was in exclusive control of its facilities, employees, and agents, including Stanford. Plaintiffs know, according to paragraphs 39 and 40, that the session tried to intervene in Stanford having sleepovers at his home. As Mr. Smith mentioned, Stanford refused, and the sleepovers continued. And only after that confrontation, apparently, did Stanford begin to abuse the plaintiffs. Plaintiffs reported this abuse to a Woodland Presbyterian Sunday school teacher in the late 1990s. And they also confronted Stanford about his conduct in front of the Sunday school. Thereafter, plaintiffs know that Stanford continues serving as the lead pastor at Woodland. And plaintiffs specifically allege, this is in paragraph 43, that their pain and suffering and anxiety were made even more intense by Woodland's refusal to take their allegations seriously, to conduct a thorough investigation of the allegations, and by Woodland's decision to allow Stanford to continue serving as lead pastor without any punishment. So at the time that these events transpired in the 1990s, plaintiffs are alleging specifically that Woodland caused them harm. They know who caused them harm, and they know that they were harmed. So those are the two points that are critical for them to have a cause of action against Woodland. And they acknowledge that they had that information, that necessary information, in the 1990s. Moreover, plaintiffs knew specifically that Stanford was an agent and or employee of Woodland Presbyterian Church, including its session in the 1990s, and that Woodland Presbyterian Church caused emotional harm, anxiety, and other injuries, pain and suffering, loss of enjoyment in life due to its actions and inactions. This is included in the complaint in paragraphs 74 and 75. So it's quite clear from plain reading of the complaint that plaintiffs knew about Woodland's involvement in their claims in the 1990s, yet failed to file within the applicable statute of limitations. My time is running out. I don't know if you had any other questions that I can address before it expires.
I hear no questions, so thank you for your argument. We'll hear from the counsel for the next appellee.
Thank you, Your Honor. This is Jill Steinberg from the Memphis Bar, and I represent Presbyterian of the Mid-South. So I want to add to Mr. Erisman's argument about why the dismissal of this case pursuant to the statute of limitations was correct by the trial court. Mr. Smith brought up the issue of fraudulent concealment and his reliance on the Red Wing case. And I think it's important to look at the differences in the Red Wing case and the case that we have here. First, with respect to the Red Wing case and the discovery rule, the cause of action accrues when an injury occurs or is discovered, or when in the exercise of reasonable care and diligence, it should have been discovered. So when a plaintiff discovers both an injury and the identity of the person or persons whose wrongful conduct caused the injury, a plaintiff cannot delay filing suit until all the injurious effects or consequences of actionable wrong are fully known, or until the plaintiff knows the specific type of legal claim that it has. I believe Your Honor specifically asked a question regarding the complaint itself, and where the plaintiff had alleged that they had made an unreasonable inquiry, and where the plaintiff had alleged that there was actual fraudulent concealment. So the discovery rule is not intended to permit a plaintiff to delay filing suit until they know all the merits of the claim. But what's really important here, Your Honor asked a question about, did they know the organization of the church? If you look at paragraph 18 of the complaint, they allege the organization of the church in that paragraph and make no comment about how that they did not know that or could not have discovered the organization of the church at that time. So on the fraudulent concealment issue, I think it's important to show the difference between Red Wing and the case that we have here. Because in Red Wing, there were allegations that the court said stated a claim. They included things such as that the defendant had instructed church officials in destruction of evidence, that the defendants had threatened and coerced victims to withdraw complaints, that the defendants had paid hush money. So the allegations in the complaint we have here state nothing about fraudulent concealment and that anyone fraudulently concealed that the plaintiffs had a cause of action or had a complaint. On the contrary, the complaint itself states that the plaintiffs knew that they had been abused at the time, that they drew it to people's attention, and that it made them anxious that no one had done anything about it. So they knew that no defendants did anything about it. I would like to add also, Your Honor, on the issue of the default judgment and the discovery issues that have been raised in this case, is that should the court, which we believe it should, affirm the dismissal of the defendants on the statute of limitations and the appellate process is completed, those issues will be no longer applicable. In other words, if the defendants are all dismissed and if the case is finally dismissed by the Supreme Court, should plaintiff go there, then dealing with issues of discovery as to Pastor Stanford, dealing with issues as to a default judgment against Pastor Stanford will be no longer relevant. And so we also want to submit to the court that we believe that the judge was correct during this time and not granting a motion for default as to Pastor Stanford, because as the Froh case indicates, the U.S. Supreme Court case and its progeny, that if there could be inconsistent results and the case is not going to be disposed of, when you have allegations of joint liability or joint venture or vicarious liability, the court should not grant a default judgment. For all these reasons, Your Honor, we believe that the complaint itself does not state a claim, and it should be dismissed pursuant to the statute of limitations, and there are no allegations of fraudulent concealment that would toll the statute.
Let me interrupt you before you run out there. Yeah. What about, does the fact that the trial, as I recall, the trial court made the judgments final pursuant to Rule 5402, no just cause for delay and so on, is that correct?
Yes, and the court did that because we asked them to do it because we wanted plaintiff to go ahead and have an opportunity.
Does that make it a different situation from what you're talking about, where you've got one default maybe entered, whether or not this default should be entered against this one party, but the all others are still here ready to be tried? I mean, hadn't they already had the fact that the trial court had already kind of cut them out and said, these are final, take your appeal now or lose it forever?
Because while it's final, pursuant to Rule 54, it's not final because there is still an appellate process. And so until the appellate process is exhausted because of the possibility that a defendant could be sent back, we believe that the court was correct in indicating that until all of the defendants' liability had been adjudicated, that the court should not grant a default judgment because it could make for inconsistent findings, especially when there's an allegation of vicarious liability and joint venture while we're in the appellate process. As soon as the appellate process is over, and we hope that the court will affirm the dismissal of the case, then it would be a different story.
All right, thank you, counsel.
Thank you.
Here from for the next appellee.
Good afternoon, Your Honor. William Johnson on behalf of Synod of the Living Waters. In furtherance of Ms. Steinberg's arguments regarding the issue of inquiry notice, I think that counsel has demonstrated that the plaintiffs were cognizant of the potential that they had a claim and the statute of limitations began to run. In addition to what Ms. Steinberg cited regarding the plaintiff's knowledge of the other entity church defendants, she told you about paragraph 18 that said Woodland Presbyterian Church was part of the Presbyterian of the Mid-South, which was part of the Synod, and all were part of the Presbyterian Church. Well, paragraph 73 actually states that the appellants looked to Woodland Presbyterian Church, Presbyterian of the Mid-South, Synod of the Living Waters, and PCUSA for guidance, education, instruction, and spiritual growth. And they further allege that they were in a fiduciary relationship with all these entities. So that just further goes to the point that they were on inquiry notice. In addition, at paragraphs 43 and 97, they say that the entity defendants, namely the Presbyterian of the Mid-South, Synod of the Living Waters, and Presbyterian Church, intensified their pain, suffering, and anxiety due to their acts and omissions in refusing to take their allegations seriously, refusing to conduct a thorough investigation of their claims, and allowing Mr. Stanford to continue serving as a cleric in the church. Now, relative to the fraudulent concealment argument, the statute of limitations is told when the appellee has taken steps to prevent the plaintiff from discovering he was injured. Here, there are no allegations that the Synod affirmatively concealed anything. The complaint, in fact, is devoid of any allegations in that regard. In fact, it's devoid of any allegations as to any of the entity defendants. And there's no allegation that demonstrates that the appellants could not have discovered the injury or the identity of the wrongdoer, because we know they knew who the wrongdoer was. We know that they knew that they were being abused by Mr. Stanford when he was the pastor of the church at the church owned and operated home in which he was living at the church's will. We also know that they knew they had been injured. So when you look at the totality of these facts, there is no evidence that the statute of limitations has not run, and there is no evidence that there's any exception to the statute of limitations. I have nothing further to add beyond that, Your Honor, unless there's any questions.
I hear none, so thank you.
Thank you.
Next, please.
May it please the court, Your Honor. Jeremy Rogers on behalf of Presbyterian
Mr. Roger,
Church.
are you the last one in line?
I think Mr. Underwood follows me.
Okay, so one more after you. Fine. Thank you. Go ahead.
On behalf of the Presbyterian Church USA, a corporation based here in Louisville, Kentucky, and incorporated under the laws of Pennsylvania, I want to shift focus slightly from the arguments that have been made about limitations period, tolling mechanisms, and focus on a unique argument, somewhat unique argument for my client in this case, which is personal jurisdiction or lack thereof.
That was the basis for the trial court's dismissal as to your client, correct?
Correct, Your Honor. I think personal jurisdiction obviously is a threshold question that's got to be resolved before anything else. Conceptually, obviously, the limitations period argument and the failure to state a claim argument would apply to my client if the threshold argument weren't dispositive, which it is here. It's important to recognize, and this is borne out in the complaint itself, how the ecclesiastical or religious structure of the denomination is set up, and contrast that with the civil corporate structure of these entities. So from a religious standpoint, you've got Pastor Stanford, who's employed by the local church, the Woodland Presbyterian Church, which is its own nonprofit corporation, and which in paragraph 17 of the complaint is alleged to have been in exclusive control of its facilities and personnel, including Pastor Stanford. Above that in the religious hierarchy is the presbytery, Ms. Steinberg's client. Above that in the religious ecclesiastical hierarchy is the synod, Mr. Johnson's client, And at the top, representing the General Assembly, the national church, is my client. That's from a religious standpoint. From a civil corporate standpoint, we have in Tennessee the presumption of corporate separateness. Each one of these entities is separately incorporated as a nonprofit corporation. So when you look at it through that lens, from a civil corporate lens, what is it that my client is alleged to have done here? And the answer is nothing, really. Certainly nothing specific to the state of Tennessee. You've got, from a jurisdictional standpoint, two different abilities to create personal jurisdiction. One is general jurisdiction, which typically is just the state of incorporation or the principal place of business. There really is no allegation of general jurisdiction against the A corporation, my client here. In fact, we argue that that argument was waived in the plaintiff's response to our motion to dismiss. They did not make a substantive argument about it. That leaves you really with the specific jurisdiction argument, which is, what is the activity or action or omission that my client is alleged to have undertaken that purposefully availed itself of the state of Tennessee? The answer to that question, Your Honor, is nothing. Nothing whatsoever in this case. My client is alleged to have done two things, really one and a half things here. Number one, it is alleged to be from a religious standpoint, an ecclesiastical standpoint, at the top of the hierarchy, so to speak. That has nothing to do with the state of Tennessee or with these particular plaintiffs or the allegations from which arise the claims here. The second thing is that my client is alleged to have published some sort of study or paper in the early 90s, generally recognizing the idea that clergy sex abuse or abuse of minors is a generalized risk in the world and something should be done about it. None of those things avails my client of the jurisdiction of Tennessee here. And so the trial court appropriately granted our motion to dismiss under 1202 paragraph 2 for failure to establish jurisdiction. Thank you, Your Honor.
All right, thank you, counsel. Hear from the next, please.
I'm the final one, Your Honor. Richard Underwood on behalf of Presbyterian of the Central South and Evangelical Presbyterian Church. My clients are almost like drivers that came up on the scene of an accident after the fact and get sued. My clients had nothing to do with anything from the 90s. Woodland was not a member of Presbyterian of the Central South until about 2012, so it was well after these events from the 90s. So my clients have nothing to do with any statute of limitations. The limited, Mr. Rogers addressed the issue. Evangelical Presbyterian Church, my client there was dismissed for lack of personal jurisdiction. And it's worth noting that in the alternative, the court said that it would have granted the 12B6 motion. So there's no jurisdiction as to Evangelical Presbyterian Church. And in the alternative, the 12B6 was granted. The 12B6 was granted as to Presbyterian of the Central South, as stated by the court. And essentially what the plaintiff alleges here in regard to my clients is that they're somehow vicariously liable for the pastor at Woodland allegedly disclosing the identity of these people that subsequently contacted Woodland in 2019. But there's no allegation of any agency between them. There's no allegation of any duty. And on those basis, for my clients in regard to this 2019 alleged conduct, I think the court appropriately dismissed them. And I don't think there's anything else I can add. It's been well briefed and we addressed those issues in the briefs and they've certainly been addressed in the arguments today. But my clients are entitled to have their dismissals upheld and on the basis set forth by the court or on the alternative basis set forth by the trial court. Thank you. And I don't have anything else.
Thank you, counsel. We'll hear from the appellant in rebuttal.
We start with Woodland's argument, and Mr. Earlsman, Mr. Johnson, Ms. Steinberg, all three made arguments to you where they conflate the allegations in the complaint as establishing that these young men as children knew everything about who is involved, what the hierarchy was, and the interrelationships and responsibilities conflated with the fact that in actuality, they only learned that in 2019, period. All of them have misstated what the complaint alleges. The complaint does not allege that they knew all that information back when they were children in the mid-90s. It establishes in the allegations that that was information they learned when these inquiries happened in 2019. He also argued on behalf of Woodland that NIAID always requires a catastrophic injury. It does not. There's no law that says that or even suggests that or even remotely implies that. Not to mention that the inference that they create here is that there was no significant harm done by this revealing of their names to the media, and we strongly disagree with that. All of them argue that these young men, children, knew everything that there was to know about who, what had happened to them, and what the injury was. And the complaint could not make clearer that that is not the case. And just like in Red Wing, they knew they had been abused by Pastor Stanford. They knew that they had gone and finally and complained to the Sunday school teacher. They were not believed and they were shut down. And that was all they knew back then. And the complaint is very
Well, I mean, counsel, I mean, they knew that he was the pastor at Woodland Church, didn't they?
He did know, they did know that.
And I'm talking about now when I say they knew, certainly at the time they reached age majority, not when they were teenagers.
They did. And to take that a step further, though, that is not to equate that to them having the legal knowledge of what the responsibility is in that hierarchy for vicarious liability, et cetera. Someone argued on behalf of the defense that they knew that the church owned that house. That's not in the record. They did not know about the Sessions inquiry that allowed this to go on because they did not do it appropriately. They did not know about the organization. You asked me earlier, and I will concede as I did then, is there a point in the intervening years where they theoretically could have found out about the hierarchy? Yes, it did not occur until 19, but even if they knew and had some way to access what the hierarchy was, it would not have revealed to them all this information from the early 90s study and rejection of policies and the Sessions malfeasance when the suspicion about Stanford arose in the mid-90s. All of that would have prevented what happened to them. Ms. Steinberg argued about the prohibition on the discovery relative to Stanford. She didn't mention that the court didn't allow us to take any discovery on the issues, the motion to dismiss about the interconnection of these institutional defendants, both as to the substance and the substantive facts of the case and as to matters that would pertain to jurisdiction. And we should have been entitled to that discovery before the motion to dismiss was granted. My time is up and I thank you.
The courts, we appreciate counsel for all sides, but for your oral argument today and as for your briefs. I believe the issues have certainly been well presented to the court and the parties' respective positions as to those issues. If you would please, Ms. Dempsey, recess court until our next scheduled case.
This honorable court is in recess until 3 p.m.
Thank you.